Real estate exam questions with answers and explanations, part number 21. Which of the following types of loans is considered a form of seller financing? A. Conventional loan. B. FHA loan. C. Purchase money mortgage. D. VA loan. Correct answer, C. Purchase money mortgage. A purchase money mortgage is a loan provided directly by the seller to the buyer as part of the purchase transaction. Instead of borrowing from a bank, the buyer finances all or part of the purchase price through the seller. This is a common form of seller financing. For example, the seller agreed to finance part of the purchase price through a purchase money mortgage. This means the buyer borrowed money directly from the seller rather than a traditional lender. Which contractual term on a lease describes the extent to which the lessor temporarily transfers the property to the lessee? A. Option to renew. B. Consideration. C. Conveyance. D. Covenant. Correct answer, C. Conveyance. In lease law, conveyance refers to the transfer of rights in real property from one party to another. In the case of a lease, it is a temporary conveyance, meaning the lessor grants the lessee the right to use and occupy the property for the lease term, without giving up ownership. For example, the lease operated as a conveyance of the property to the tenant for 3 years. This means the landlord transferred the right of possession and use to the tenant temporarily, while still retaining ownership. Susan owned a double lot on the waterfront. She sold the lot to David and included a deed restriction prohibiting construction of any building taller than 1 story. David wants to build a 3-story house. What should he do? A. Apply for a zoning variance. B. Ignore the restriction and build the house. C. Confirm the deed restriction prohibiting construction and seek a court to have the restriction removed. D. Apply for a building permit. Correct answer, C. Confirm the deed restriction prohibiting construction and seek a court to have the restriction removed. A deed restriction is a private limitation placed on the property by the seller or developer and is legally binding on future owners. Unlike zoning rules, which can sometimes be modified with a variance, deed restrictions remain enforceable unless removed or altered through court action. David must first acknowledge the restriction that Susan placed in the deed and then challenge it legally if he wishes to build a 3-story home. For example, David cannot simply apply for a zoning variance because the deed restriction was created by Susan, not the municipality. This means he must confirm the deed restriction and go through court action if he wants it removed. Frederick is purchasing a bank-owned property. His real estate agent tells him the bank is offering insurable, not marketable, title. What does this mean to Frederick? A. The title is completely free of defects. B. The title has known defects, but a title insurance company is willing to cover potential losses. C. The title guarantees no risk of future legal claims. D. The title is equivalent to a general warranty deed. Correct answer, B. The title has known defects, but a title insurance company is willing to cover potential losses. When a bank sells a foreclosed property, it often provides insurable title instead of marketable title. An insurable title means the title company will issue insurance despite existing defects, such as unresolved liens or gaps in ownership, protecting the buyer against potential future claims. A marketable title, by contrast, is one that is free from significant defects and would be acceptable to a reasonable buyer without insurance concerns. For example, Frederick can purchase the bank-owned property, but he must understand that while the title may have issues, the title insurance policy will cover financial losses if someone later challenges his ownership. This means he's protected by insurance, but not guaranteed a flawless title. Susan is Frederick's unlicensed personal assistant. What activity may Susan perform? A. Negotiate a purchase contract with a buyer. B. Host an open house for Frederick's listing. C. Place advertisements exactly as directed by Frederick. D. Provide advice to a client about making an offer. Correct answer, C. Place advertisements exactly as directed by Frederick. An unlicensed personal assistant is not permitted to perform activities that require a real estate license, such as negotiating, showing property, or advising clients. However, they may carry out strictly clerical or administrative tasks under the direct supervision of a licensed agent, such as placing ads, answering phones, scheduling appointments, or filing paperwork. For example, Susan types and places an ad in the local newspaper for one of Frederick's listings, exactly as Frederick instructed. This means she is performing an administrative task that does not require a real estate license. Which of these entities cannot be a sponsoring broker? A. Bright Path Realty, LLC. B. Summit Real Estate, Inc. C. A sole proprietor broker. D. A real estate salesperson. Correct answer, D. A real estate salesperson. A sponsoring broker must be licensed at the broker level. That broker can operate as a sole proprietor, or under a business entity such as Bright Path Realty, LLC or Summit Real Estate, Inc. A salesperson, however, cannot act as a sponsoring broker because they lack the required broker's license. For example, Bright Path Realty, LLC can serve as a sponsoring broker because it is a licensed brokerage entity. This means an LLC may operate as a sponsoring broker with a managing broker in place. Summit Real Estate, Inc. can also serve as a sponsoring broker. This indicates that corporations may act as sponsoring brokers if they are licensed and supervised by a broker. A salesperson, however, cannot be a sponsoring broker. This means only licensed brokers, not salespersons, can sponsor other agents. What license or classes should a real estate professional get to work as a part-time property manager? A. No license is ever required for property management. B. A real estate license if state law requires it, or a property manager license where separately regulated. C. Only a home inspector's license. D. A mortgage loan originator license. Correct answer, B. A real estate license if state law requires it, or a property manager license where separately regulated. To work as a part-time property manager, the required license depends on state regulations. In many states, property managers must hold an active real estate license, since activities such as leasing, advertising rental units, or handling rent involve real estate brokerage functions. Some states, however, have a separate property management license or permit that can be obtained with specific classes. It is important to check the local real estate commission's requirements. For example, if Maria wants to manage apartments on weekends, she must first confirm whether her state requires a real estate license or a special property manager's permit. This means she cannot just start collecting rent and signing leases without the proper license. Which of these statements about a conventional mortgage loan is true? A. It is insured by the Federal Housing Administration, FHA. B. It is guaranteed by the Department of Veterans Affairs, VA. C. It is not insured or guaranteed by any government agency. D. It is only available to first-time homebuyers. Correct answer, C. It is not insured or guaranteed by any government agency. A conventional mortgage loan is a type of home loan that is not backed by the federal government. Unlike FHA loans, insured by the FHA, or VA loans, guaranteed by the VA, conventional loans are issued and serviced by private lenders and follow guidelines set by Fannie Mae and Freddie Mac. Borrowers usually need stronger credit and a larger down payment compared to government-backed loans. For example, David applies for a mortgage through his local bank, and the loan is not insured or guaranteed by the government. This means David is using a conventional mortgage loan. Susan represented Frederick in the sale of Frederick's home. They signed an exclusive right to sell listing agreement. If Frederick were able to find his own buyer, would he owe Susan compensation? A. No, because Frederick found the buyer himself. B. No, unless Susan directly introduced the buyer to Frederick. C. Yes, because Susan has the exclusive right to sell the property. D. Yes, but only if Susan is also the procuring cause of the sale. Correct answer, C. Yes, because Susan has the exclusive right to sell the property. Under an exclusive right to sell listing agreement, the broker, Susan, is entitled to compensation no matter who finds the buyer, even if the seller, Frederick, finds the buyer independently. This is the key feature that distinguishes this type of listing from an exclusive agency agreement. For example, Frederick signs an exclusive right to sell listing with Susan and later finds a buyer through a family friend. Frederick must still pay Susan her commission. This means Susan is guaranteed compensation under the agreement, regardless of who brings the buyer. Susan's mother owns several rental properties and intends to keep them to pass on to the family. Susan holds a special power of attorney, POA, to manage the rental properties, including working with the property manager to place and evict tenants as necessary. Which of these would violate the POA? A. Signing a lease with a new tenant on behalf of her mother. B. Filing eviction paperwork as attorney-in-fact. C. Selling one of the rental properties without her mother's direct consent. D. Communicating with the property manager about repairs. Correct answer, C. Selling one of the rental properties without her mother's direct consent. A special power of attorney limits authority to specific duties, in this case, managing rental operations, leasing, evictions, and tenant matters. It does not give Susan the right to dispose of assets or sell property, which would require a general or specifically stated authority in the POA. For example, if Susan signs a new lease for a tenant under her mother's name, this is valid under the POA. This means she is acting within the authorized management powers. If she sells one of the houses, this would be invalid. This implies she exceeded the authority granted by the special POA.